They sold my 5,200-acre farm while I was away, forged my signature, divided the land into luxury parcels, and bragged that no rancher could fight an HOA with deeper pockets. Marlene Voss even brought buyers to my barn and called me a trespasser when I returned. What she never learned was why the county clerk went pale after seeing my name. 3 weeks later, the HOA board marched into court expecting an easy eviction. Then the courtroom fell silent. He stepped through the side door, took his seat behind the judge's bench, and watched Marlene realize whom she had defrauded. Stay until the verdict, because Marlene's forged deed was only the first secret buried beneath the stolen farm that day. Everett Calloway had been away from Red Hollow for nearly 3 weeks, tied up with duties at the state capitol, and all he wanted now was a quiet stretch of days to mend fences, check the reservoir, and rest before his next session on the Procid. Bench. The gravel road curled familiar beneath his truck, tires the same bend it had taken for decades, and he expected nothing more than dust and silence. Instead, as he neared the front gate, a towering sign greeted him where none had stood before, announcing Silver Creek Grand Reserve and promising luxury homes coming soon. His own iron gate had been fitted with a new lock. 2 black sport utility vehicles bearing the Silver Creek Estates emblem sat parked just inside the property line, and a cluster of men in tailored suits were walking a group of investors past the horse barn, as though they owned every inch of it. For a moment, he simply sat in the truck engine, still running, staring at the sign as though it might resolve itself into some kind of misunderstanding, a mistaken address, a neighboring parcel confused with his own. It did not resolve. The lettering was too crisp, too new, clearly printed for a launch that had already been planned for weeks, complete with a rendering of villas standing where his hayfields had stood for generations. Everett parked, used a spare key on the side gate, and walked in without a word to anyone. Marlene Voss spotted him first, flanked by her attorney Nolan Pierce and 2 private security guards, and she did not bother to ask who he was. She announced loudly enough for the investors to hear that he was trespassing on homeowners association property. Everett told her plainly that this was his farm and asked her to leave. Marlene laughed and produced a copy of a deed transfer, which claimed that Everett had sold the entire 5,200 acres to a company called Silver Basin Development for $11,800,000. He studied the signature at the bottom close enough to his own hand to fool a stranger, but he had never signed it. The documents also claimed he had granted power of attorney to a man named Calvin Rusk, a name Everett had never once heard in his life. Nolan warned him that the Homeowners Association had lawfully purchased development rights from Silver Basin, and that if he did not leave immediately, they would have him arrested for trespassing on land that was no longer his. Everett did not argue. He simply asked Marlene whether she had bothered to check who she was buying land from. She answered that the association had lawyers, a notary, and a county-confirmed record, and she mocked him for imagining a lone farmer could stand against an entire board with real money behind it. One of the investors, a younger man in a gray suit, asked Marlene quietly whether this kind of confrontation was normal, and she waved him off, assuring him the previous owner was simply having trouble letting go, nothing that would affect the closing timeline. Everett photographed the sign, the vehicles, the paperwork, and every face present, saying almost nothing, moving with the unhurried calm of a man who had spent decades watching people talk themselves into far more trouble than silence ever could. Marlene watched him circle the property with his phone raised, mistaking his quiet for weakness, and she leaned toward one of her security guards and murmured that men like him always back down, once they realized the paperwork was already recorded with the county. Before he turned to leave, he looked directly at her and told her she should have her lawyer check his name one more time. Marlene dismissed it as the desperate bluff of an old man losing his land. Everett did not call an attorney that evening. He called the county land records clerk directly and told him to lock down every file connected to Red Hollow because someone had just sold his farm using a forged signature. His voice on the phone was even almost conversational, the voice of a man giving directions, rather than a man whose life's work had just been stolen out from under him, and Lyle later admitted that steadiness was what convinced him to act immediately rather than wait for morning. The next morning, Everett walked into the county land records office, and the clerk Lyle Benton went pale the moment he saw the name on the counter. Lyle explained that 3 weeks earlier, a full electronic transfer package had been filed, complete with a power of attorney bearing Everett's signature, a sales contract, a notarized statement, a property inspection report registration, papers for Silver Basin Development, and a subdivision map splitting the 5,200 acres into 312 development lots. Lyle admitted he had briefly hesitated since Red Hollow had belonged to the same owner for so many years. But the filer had supplied the correct tax parcel numbers, matching legal descriptions, and a copy of what appeared to be Everett's identification. He confessed that in 20 years behind that counter he had processed thousands of transfers, and while something about the pace of this one had felt slightly off the paperwork itself, had appeared complete enough that flagging it without cause could have opened the county to its own liability for delay. He had even called the phone number listed on the file, and a man claiming to be Everett had confirmed the sale over the line. Everett asked Lyle to preserve the original documents, the computer access logs, the internet addresses tied to the filing, and any security footage from that day, and Lyle agreed without hesitation. While that conversation unfolded, Marlene was holding an emergency homeowners association meeting across town, announcing to the board that Silver Creek Estates had just secured the largest land acquisition in the county's history. Her plan, as she laid it out, included 180 luxury villas, a private golf course, an artificial lake, a conversion of the historic horse barn into a restaurant, and a special new membership fee for every existing homeowner in the private community. A few board members asked what had happened to the previous owner, and Marlene told them Everett had sold the land, then changed his mind once he realized how much the development rights were truly worth. She called him a greedy old man, attempting to extort the association after the fact. Nolan began preparing a lawsuit, accusing Everett of trespassing, interfering with a legitimate transaction, and causing significant economic harm, along with a request for a restraining order barring him from ever returning to the farm. Everett received that lawsuit by that same evening, and what caught his attention was not the accusations themselves but the date printed on the power of attorney, since it matched a day he had spent presiding over a public court session at the state capitol in front of dozens of witnesses. Court staff, official recordings, and a packed courtroom could all confirm he had never left the Capitol that day, let alone traveled home to sign anything. He also recognized the forged signature as a near-exact copy of one he had placed on a court ruling nearly 2 years earlier, a document that had long been part of the public record. Late that night, Everett opened the state's business registry and searched for Silver Basin Development, discovering the company had been incorporated only 11 days before it supposedly purchased his farm. Its registered address matched almost mockingly the exact office suite belonging to Nolan Pierce. Everett sat with that fact for a long while, turning it over the way he might. A piece of evidence submitted in his own courtroom, and he found himself almost amused at how little effort had gone into hiding the connection. As though whoever built this scheme had never imagined the man they were stealing from would ever bother to look. That night alone in the farmhouse kitchen, where he had eaten breakfast for more than 2 decades, Everett laid every page of the fraudulent packet across the table and studied it the way he once studied briefs before handing down a ruling. He noticed small things nobody in a hurry would ever catch. The slightly wrong shade of blue ink on the signature line, a margin that shifted by a fraction of an inch halfway through the document, a notary stamp pressed just a little too hard, as though the person using it had never used a real one before. He did not feel panic. He felt the same cold clarity he had felt decades earlier, back when he was still a young attorney, untangling fraudulent land titles for families who had no idea their property had been quietly stolen out from under them on paper while they slept. Everett chose not to confront Marlene directly, instead beginning the quiet, methodical work of building an evidentiary record the way he had trained lawyers to do for 30 years. He hired independent counsel Fletcher Rowe to file an emergency motion freezing any further transactions connected to the farm, and he deliberately avoided using his judicial title to contact any agency, wanting every piece of evidence gathered as though he were an ordinary citizen with no special standing at all. He brought in Tessa Whitmore, a state document examiner known for her precision, to review every page of the filing. Within days, she returned findings that turned suspicion into certainty. Tessa found that Everett's signature had been digitally composited rather than written by hand, that the ink on the signature page did not match the ink used elsewhere in the document, and that the notary seal belonged to a woman who had left her position months earlier. Her registration number expired for over half a year. The photograph used for his identification had been lifted from an old court filing, and portions of the power of attorney text had been copied directly from a generic legal template available online. Lyle supplied security footage from the records office showing that the person who had physically filed the documents was a young woman employed by Nolan Pierce's law firm. Computer logs traced repeated edits to the file back to an internet address inside the Homeowners Association's own headquarters. Everett also discovered that Silver Basin Development had never actually paid the $11,800,000 listed on the sale. Instead, only $118,000 had moved into an escrow account, after which the fabricated purchase agreement was used to secure a $7 million loan from a private investment fund. Portions of that borrowed money had flowed into the Homeowners Association's operating account, a consulting company owned by Marlene, Nolan's law office, and a construction firm run by a member of the association board. This was never only about seizing a farm. Marlene was using stolen land as collateral to pull millions of dollars out of a lender who believed the transaction was real. Everett recognized the structure immediately, having presided over similar cases decades earlier as an attorney, back when he specialized in unwinding exactly this kind of layered deception before it could collapse onto innocent people. He understood that schemes like this rarely stayed contained, that the borrowed money would eventually need, replacing that new victims would be recruited to keep the fraud from being discovered, and that the longer it continued, the more people stood to lose everything once it finally came apart. That understanding was what convinced him to move carefully, rather than rush toward confrontation, because a scheme this large needed to be dismantled completely, not merely interrupted long enough for its architects to rebuild it somewhere else. Marlene's crew arrived days later to tear down the eastern fence line, and Everett stood outside the property recording every moment on his phone rather than intervening physically. She taunted him, telling him he could film all he wanted because by the time any court hearing arrived, the land would already be a construction site. Everett answered quietly that she was manufacturing new evidence with every minute her crew spent there. Tessa's next discovery was more alarming than the fraud itself, since the forged power of attorney did not merely authorize the sale of the surface land. It also granted authority to mortgage the property, subdivide it freely, and transfer every underlying mineral right, meaning Marlene had attempted to steal not just the farm above ground but tens of millions of dollars in resources buried beneath it. Marlene launched a public campaign to isolate Everett from any sympathy in the community, sending a notice to every resident of Silver Creek, claiming that he had voluntarily sold the farm, was now demanding more money, was threatening construction workers, and was trying to destroy the value of everyone's homes by refusing to accept a legitimate sale. She organized a press event directly outside the Red Hollow Gate, standing beside a large map of the proposed development and declaring that the association had acted entirely within the law. Everett appeared, but did not argue with her in front of the cameras. He simply asked whether she was prepared to swear under oath that she had personally spoken with him before purchasing the land, and when she answered yes, he asked her to name the exact date of that conversation. Marlene gave a specific date without hesitation, one that happened to fall on the same day. Everett was attending a judicial conference in another state entirely, a detail several reporters quietly noted down. Nolan, standing nearby, recognized instantly that Marlene had just exposed herself to potential charges of perjury and fraud, and he abruptly ended the press event before further questions could be asked. Afterward, Marlene attempted to settle privately, offering Everett $500,000 if he would sign a statement confirming the sale had been legitimate. When he refused, she raised the offer to $1 million, then $2 million, and Everett calmly insisted that every offer be put in writing before he would even consider it. Believing he was softening, Nolan sent a formal settlement letter suggesting that if Everett cooperated in confirming the transaction, the association would compensate him further for his silence. That letter, intended as leverage, instead became powerful evidence that the homeowners association already suspected the original sale was fraudulent. Fletcher Rowe later described it to colleagues as the single most useful piece of paper in the entire case. Since no forensic analysis or expert testimony could ever be as persuasive as the opposing side's own attorney, admitting in writing that a payment was needed to make an inconvenient truth disappear. Around this time, County Sheriff Grant Holloway paid Everett a visit, initially explaining that ownership disputes usually fell under civil rather than criminal jurisdiction. Everett handed him the signature analysis, the video of the filing, the internet access logs, the wire transfer records, the settlement letter, and clear documentation proving he had been hundreds of miles away on the day he supposedly signed the papers. Grant's posture changed almost immediately as he flipped through the file, and he told Everett this now looked like a case involving document forgery, bank fraud, property theft by deception, money laundering, conspiracy, perjury, manipulation of the county's land registration system. He asked Everett, almost puzzled, how the homeowners association could possibly not have known who he really was. Everett looked toward the farmhouse in the distance and answered simply that he had never needed a title to prove the land belonged to him. He added that most people who came looking to take something from him assumed an old man living alone on a large piece of land had nothing behind him worth checking, and that assumption more than any forged signature had always been their greatest miscalculation. Grant admitted almost sheepishly that when the initial complaint about a trespassing rancher first crossed his desk, he had nearly assigned it to a deputy to handle as a routine property line squabble, the kind of dispute his office settled, a dozen times a year without much thought. It was only the sheer volume and precision of Everett's evidence, organized in chronological order, with dates, timestamps, and cross-references, that convinced him this was something far larger than a disagreement between neighbors. He told Everett that in 22 years of wearing the badge, he had rarely seen a private citizen build a case file this clean, and Everett only replied that he had simply refused to let anger cloud what needed to be documented first. Nolan filed for an emergency order demanding that Everett be barred from ever entering Red Hollow again, that control of the property be handed to the homeowners association, that Everett be forced to pay damages for delaying construction, and that the association be allowed to continue subdividing the land while the dispute remained unresolved. In his filing, Nolan described Everett as an elderly man with no legitimate claim who was harassing the rightful new owners, and Marlene fully expected a judge to glance at the registered deed and order him removed within days. What neither of them realized was that the case had been filed in the very district court where Everett served as presiding judge. Everett immediately disclosed in writing that he was a party to the case, withdrew entirely from any role in assigning a judge, and requested that an independent judge from another district hear the matter instead. Judge Rosalind Mercer was assigned to preside, and Everett committed publicly to avoiding any procedural involvement, any private contact with her, any use of court staff for his personal matter, and any appearance except as a counter-plaintiff represented by his own attorney, Fletcher Rowe. On the morning of the first hearing, however, Everett still had an unrelated administrative swearing-in ceremony on his calendar for newly appointed court staff scheduled, long before any of this began. Marlene and several board members arrived early, certain their hearing was about to begin, talking loudly behind the gallery as Marlene mocked Everett as a delusional rancher who would be dragged off his own land by the end of the day. The side door beside the bench swung open, and a court officer announced that Chief Judge Everett Calloway would be presiding, and Everett walked in wearing his black robe and took his seat behind the bench exactly as he had thousands of the pouted times before. Marlene froze in place. Nolan's folder slipped from his hands and scattered across the floor, and the board members exchanged stunned glances as they finally understood that the man they had branded a trespasser was the very judge whose courtroom they had just filed their lawsuit in. Everett did not preside over his own case. Once the brief administrative ceremony concluded, he stated clearly for the record that he was a party in the upcoming matter and had already withdrawn from any judicial role connected to it, then removed his robe and walked to the plaintiff's table beside Fletcher Rowe. Judge Rosalind Mercer entered from chambers moments later to take over the hearing, and the shock in that room had nothing to do with Everett wielding power against his opponents. It came from the realization that the Homeowners Association had forged the signature of a man who understood the legal system better than anyone else in the building. For a long moment, nobody in the gallery moved, and even the court reporter's fingers hovered over her keyboard as though she too needed a second to process what had just happened. Marlene finally found her voice and whispered to Nolan that this had to be some kind of trick, some procedural maneuver meant to intimidate them before the real hearing began. But Nolan only stared straight ahead, already running through every filing he had signed, and wondering how carefully a sitting judge might have read them. When Everett rose, removed his robe, and crossed the room to sit beside Fletcher Rowe at the plaintiff's table, several board members in the back row quietly stood and slipped out the rear doors, unwilling to be photographed anywhere near what was clearly about to become a very public reckoning. Judge Mercer asked Nolan whether he intended to proceed with the eviction request immediately, and he hesitated, glancing toward Marlene, who leaned in and ordered him to continue, insisting the county land record was firmly on their side. Nolan opened by arguing that the county record recognized Silver Basin Development as the legal owner, and that the Homeowners Association had purchased development rights in good faith, investing millions on the strength of that record. Fletcher did not dispute that the filing existed, only that it had been created through fraud from the very beginning. He began with Everett's calendar, showing that at the exact hour the power of attorney was notarized, Everett had been on the bench more than 300 miles away, in a fully recorded public session witnessed by dozens of people. Tessa Whitmore took the stand next and explained with two enlarged signatures displayed side by side that the forged version matched a prior court ruling with a precision no natural human signature could ever replicate. She then described the expired notary registration, noting that the woman whose seal appeared on the document had confirmed under oath that she never signed or stamped it, and that her missing seal had last been seen inside Nolan Pierce's own office. Security footage from the county records office followed, clearly showing Nolan's assistant physically filing the fraudulent papers, and digital forensic logs traced repeated edits to computers inside both the law firm and the Homeowners Association's internal network. Marlene attempted to shift blame onto Nolan, insisting she had simply trusted the paperwork he prepared, while Nolan countered that he had only acted on documents Marlene herself supplied to him. Judge Mercer noted openly that the two of them were now offering the court contradictory accounts of the same events. When questioned directly, Marlene claimed she had personally met with Everett twice before purchasing the property, but Fletcher produced surveillance footage, travel records, and Everett's official calendar proving he had been nowhere near the county on either date she named. She changed her account, suggesting she must have met with someone representing him instead, and when asked to name that representative, she repeated the name Calvin Rusk. A prosecutor observing the hearing informed the court that no such person existed, and that the Social Security number listed under that name belonged to a man who had died years earlier, a detail that visibly rattled both Marlene and Nolan at the defense table. Fletcher then introduced an internal email provided by a cooperating board member, in which Marlene had written to a colleague that the old man barely spent time at the farm anyway, and that once the paperwork was recorded, it would take him years to ever win the land back. The courtroom fell completely silent as the words were read aloud. Judge Mercer looked directly at Marlene and asked whether she had just described a real estate transaction or a calculated plan to seize someone else's property. Marlene's attorney requested a brief recess, and during the 10 minutes the courtroom emptied into the hallway. Several residents of Silver Creek, who had come only out of curiosity, began speaking quietly among themselves, recalling meetings where Marlene had pushed through unusual votes with little explanation, dues increases nobody fully understood, and maintenance contracts awarded without competitive bidding. One elderly resident approached Fletcher Rowe in the hallway and asked, almost apologetically, whether it was too late to have her own homeowners association records checked for similar irregularities. And Fletcher told her that after today, plenty of communities across the county would likely be asking the very same question. When the hearing resumed, the mood in the gallery had shifted entirely. No longer curious spectators, but a room full of people quietly recalculating how much trust they had placed in a name and a title rather than in verified facts. The court paused the eviction request and authorized a full financial investigation, and Sheriff Grant Holloway's fraud unit seized computers from both the Homeowners Association office and Silver Basin Development within days. What they uncovered showed Marlene had been planning this for nearly a year, driven by a financial crisis inside the association itself. One built from years of overspending maintenance contracts awarded to friends and allies, a reserve fund drained almost to nothing, and a failed community center project that had quietly buried the association in debt. Marlene had concealed a shortfall exceeding $2,600,000, and she needed a large asset to mortgage in order to keep the entire organization from collapsing. Red Hollow, bordering the community with its own water rights, road access, and valuable mineral deposits, became her target, and once the forged paperwork was filed, she planned to use the farm as collateral for a substantial loan. Nolan had helped establish Silver Basin Development as a shell company for that exact purpose, and a cooperating appraiser had produced a fraudulent valuation, inflating the farm's development potential to $42 million, which the group then used to secure a $7 million loan. Investigators traced the money and found that $2,600,000 had covered the association's hidden deficit. $1,400,000 had gone into Marlene's private consulting company. $900,000 had been paid to Nolan under the label of legal fees. $1,100,000 had gone to a board member's construction company, and the remainder disappeared into broker fees meant to keep the entire scheme hidden. Board members who once stood firmly behind Marlene began turning against her once the numbers surfaced, with one supplying incriminating emails, another handing over a recording from a private meeting, and a third admitting she had once said, "The more a landowner spent fighting in court, the cheaper he would eventually sell for." Marlene still believed she could avoid responsibility by claiming she had simply followed her attorney's advice, while Nolan insisted the opposite, that Marlene had supplied every document and pressured him to move quickly. The two continued publicly contradicting each other as investigators pieced together the full scope of the fraud. Then came a discovery that eliminated any remaining doubt about her true motive. Inside a personal safe belonging to Marlene, investigators found a second hidden agreement, stating that once the development was approved, she would personally receive 8% ownership in the finished project, an interest projected to be worth more than $6 million. This was never about rescuing a struggling homeowners association from financial ruin. Marlene had stolen an entire farm to enrich herself, using the community's name and the residents' trust as cover for a private fortune she intended to keep quietly for herself. Investigators later reconstructed the timeline in full and found that Marlene had first approached the appraiser nearly 14 months earlier, long before the fabricated documents ever existed, asking hypothetically what a large, undeveloped parcel bordering the community might be worth if it were ever subdivided. She had driven the boundary roads of Red Hollow alone on several occasions that year, photographing the water access points and the old mineral survey markers, building a private file long before Everett ever suspected anything was wrong. What made the discovery in her safe so damning was not simply the hidden percentage she intended to collect, but a handwritten note clipped to the agreement in her own handwriting, listing the projected payout beside a rough sketch of a probable house she had circled in a real estate catalog, a home well. Outside the county, far from Silver Creek and everyone in it. Sensing the investigation closing in, Marlene called an emergency late-night meeting of the Homeowners Association Board, demanding a vote to fire Nolan, destroy every internal record connected to Silver Basin, shift full responsibility onto the development company, and publicly frame herself as an innocent victim of misleading information. One board member secretly recorded the entire session, capturing Marlene ordering emails, deleted hard drives, wiped, and prior meeting minutes altered to erase her fingerprints from the plan, while she also proposed using association funds to pay a low-level office employee to falsely take the blame for the forged paperwork. By the next morning, a small fire had broken out in the association's records room, though the sprinkler system extinguished it before the archive could be fully destroyed. Investigators traced the origin of the fire to a storage container holding Silver Basin's paper files and hallway security cameras, placed Marlene inside the building well after midnight. She insisted she had only come to collect personal belongings and had nothing to do with the blaze, but a search of her vehicle told a very different story, revealing 2 hard drives removed from the association's servers payment, records tied to her own consulting company, a burner phone used to place the fake confirmation call to the county clerk, a duplicated copy of Everett's identification, and the missing notary seal itself. Grant arrested Marlene on charges of evidence tampering and obstruction of an active investigation, and Nolan was taken into custody shortly after. Once recovered, data proved he had personally drafted the forged power of attorney, directed his assistant to file it. As she was being led away, Marlene turned to Everett and accused him of using his judicial position to destroy her. He answered quietly that he had never needed his position to defeat her, only her own willingness to keep signing her name to every lie she told. Word of the arrest spread through Silver Creek within hours, and by nightfall, a small crowd of residents had gathered outside the association office, many of them holding printed copies of the dues increases they had paid over the past year without ever questioning where the money actually went. A handful of investors who had already signed contracts for the promised luxury lots called Fletcher Rowe's office, directly frightened and confused, asking whether their deposits were simply gone. And Fletcher assured each of them that Everett had already made clear he had no intention of punishing people who had been deceived just as thoroughly as the county records office had been. Judge Mercer subsequently froze every asset belonging to Silver Basin Marlene Nolan, and the companies connected to them in construction at Red Hollow was ordered to stop immediately. Yet one question still hung over the entire case, unresolved and urgent. What would happen to the investors and homebuyers who had already spent their savings on parcels of land that had never belonged to the homeowners association in the first place? At the final hearing, Judge Mercer delivered a comprehensive ruling, addressing every unresolved piece of the case. She declared the power of attorney fraudulent from its origin, the sale agreement void from the moment it was signed, and Silver Basin Development's claim to ownership legally non-existent, meaning the association had never possessed any right to develop, mortgage, or sell any portion of Red Hollow. Everett was formally and permanently confirmed as sole owner of all 5,200 acres, a ruling that closed the door on any future challenge to his title. The court also held the Homeowners Association and the individual defendants financially responsible for every form of damage inflicted on the property, including the destroyed fencing, the bulldozed acreage, the felled trees, the ruined interior roads, the cost of environmental restoration, the legal and forensic examination fees, and compensation for the deliberate ongoing trespass onto his land. Regarding the people who had purchased individual lots, the court determined they were victims acting in good faith and ordered full restitution drawn from Silver Basin's remaining assets: Nolan's professional liability insurance, Marlene's personal holdings, the frozen accounts, connected to the fraud, and clawbacks from board members who had personally profited from the scheme. Everett insisted he would not keep a single dollar of their deposits and refused to hold ordinary buyers responsible for decisions made entirely by the association's leadership. When one investor personally thanked him outside the courthouse, visibly relieved to learn his savings would be returned, Everett only replied that the man's mistake had been trusting a glossy brochure, not the law, and the law still had an obligation to make him whole. The broader investigation revealed that the board had breached its fiduciary duty to residents, misused the community's reserve funds, approved transactions riddled with conflicts of interest, concealed the association's true financial condition, and ultimately spent residents' money financing a criminal enterprise. The court appointed an independent administrator to take over management of Silver Creek Estates while the situation was untangled, and after a resident vote followed by further legal proceedings, the Homeowners Association itself was formally dissolved with essential maintenance responsibilities, transferred to a new voluntary association built around transparent, independently audited finances. Marlene now faced a lengthy list of criminal charges, including document forgery, real estate fraud, bank fraud, conspiracy to commit property theft, money laundering, obstruction of justice, destruction of evidence, and perjury, while Nolan was immediately suspended and later permanently disbarred from practicing law. Several board members When the ruling was finally read in full, Marlene turned to look at Everett one last time, and for the first time since this began, she did not see an old farmer. She believed she could frighten off his own land. She saw a man who had given her every opportunity to stop, and who had simply waited patiently and without malice while she chose again and again to make the case against herself even stronger. In the weeks that followed sentencing, the county newspaper ran a lengthy account of the case, and residents throughout the region began asking their own associations for full financial audits, prompting a wave of scrutiny that reached far beyond Silver Creek. Several neighboring communities discovered smaller versions of the same pattern, board members quietly steering contracts toward relatives or padding maintenance invoices. None of it as brazen as forging a signature to seize 5,000 acres, but all of it eroding the same trust that residents had once handed over without question. Fletcher Rowe found himself fielding calls from attorneys in 3 other counties, asking how Everett's team had built such an airtight paper trail, and he told each of them the same thing, that the case had never depended on cleverness, only on refusing to skip a single step. Months later, the towering Silver Creek Grand Reserve sign was finally removed from the gate of Red Hollow, and Everett spent the following weeks rebuilding the broken fence line, replanting trees that had been torn out, and repairing the interior roads that heavy construction equipment had scarred. He never built a single villa, golf course, or resort structure on the property. Instead, Everett signed a conservation agreement protecting the majority of Red Hollow, ensuring it could never again be carved apart by a speculative development scheme, no matter who tried in the future. A portion of the damages he collected went toward restoring the land that had been bulldozed, protecting the farm's natural water sources, establishing a legal aid fund to help elderly landowners who faced similar fraud, digitizing the poor county's land transaction verification system, and creating a mandatory process requiring direct confirmation with property owners before any large transaction could be recorded. Lyle Benton retired, not long after helping overhaul the county's record system from the inside out, while Tessa Whitmore became an advisor to a new statewide program dedicated to catching forged documents before they ever reached a courthouse. Grant Holloway received public recognition for refusing to treat the case as a routine civil disagreement, once real criminal evidence appeared in front of him, and Everett continued serving as a judge, though he rarely spoke of the Red Hollow case from the bench, except when explaining why the law existed to protect both the powerless and the well-informed alike. The barn that Marlene had once walked strangers through as though it belonged to her own future resort was repainted that autumn, its doors rehung, its old hayloft repaired board by board, using lumber cut from trees on the property itself. Everett hired back 2 of the ranch hands who had quietly quit during the chaos, unsure who truly owned the land they were being asked to work. And both men later said the moment they trusted things had finally returned to normal was the morning Everett walked the fence line with them at sunrise, checking posts. The same unhurried way he always had, as though nothing unusual had happened at all. The horses that had once been paraded past curious investors were let back out into open pasture, and by winter the hoofprints crossing the old trails had replaced every tire track the construction crews had left behind. One quiet morning, Everett stood at the newly repaired gate of his farm beneath the old wooden sign that read, "Red Hollow Farm Private Property," since 1891. He thought back to the exact moment Marlene had walked into that courtroom, looked up, and realized the man behind the bench was the very landowner she had tried to erase from his own deed. But Everett always maintained quietly, and without pride, that it was never the robe that had saved his farm. What saved Red Hollow was a records office that kept careful files, witnesses willing to tell the truth, even when it was inconvenient experts who did their work with integrity, a sheriff willing to look honestly at the evidence in front of him, an independent judge who refused to let power sway her judgment, and the patience to let a liar keep contradicting herself until the truth stood on its own. Marlene believed that stealing his signature meant she had stolen his land, but a forged deed can rewrite a county record. It can never rewrite the truth.